All right. Good afternoon, everybody. My name is Adam Ruttenberg. I'm a partner at Posternak, Blankstein, Lund in Boston. Introduce yourself.
And I'm Dave Chenelle. I'm a director at Perkins and Anctil in Westford.
So we're talking about exemptions, and in particular, there's three aspects that this panel is intended to cover. The first is temporal aspects of exemptions, how the passage of time can make what was exempt maybe not so much anymore. The second is the interplay with Chapter 7 and Chapter 13, because rules and exemptions that you thought of in Chapter 7 suddenly don't seem to have the same effect in Chapter 13. And the third and final thing we're going to talk about are those perennial favorites since 2005, 522 OP and Q, and in particular 522P, which even now, 12 years after BAP's CPA, is still fraught with argument about exactly how it's applied, what it means, and what's done, and a particularly recent case on that. You'll see that although we have three topics and we usually have three panelists, there's only two of us here today. Our third panelist had to drop out for some unfortunate circumstances. So we have cases on that topic in the book, but we don't have any write-up on it. We will address it to the extent that we can, but obviously it would have been better if we could have had a third panelist on that. And that's the topic we're actually going to start with, which is temporal effects of exemptions and what can happen over time. So I guess since we're talking about time, I'm going to go back in time to when I took bankruptcy in law school. And what I was taught was that, among other things, what bankruptcy is supposed to do is create an orderly liquidation to maximize asset distribution and avoid the race to the courthouse. And the way it does that is that things are frozen on the petition date. Then assets are distributed, maximized and distributed over time, and of course with the goal of trying to get creditors something that's close to what they would get outside of bankruptcy, like all bankruptcy law school courses. Mine started with Butner and the effect of state law in bankruptcy. So I learned bankruptcy with this perspective and understood the petition date is a magic date. Everything's determined as of then, what assets are in the estate, what amounts are claims, when interest stops. And I always thought that also meant what would be considered exempt. That's determined on the petition date, I thought. And then on August 6, 2014, Judge Hillman decided a case called Inri Williams. It's in the book. The site is 515 BR 395. The facts of Williams are that the debtor and her non-debtor husband were getting divorced. As part of the divorce, the marital residence got sold. There was $63,000 in proceeds above the mortgage and costs. They split that in half, $31,500 each. The debtor put her half into a segregated bank account and didn't touch it. And 10 months later, she filed bankruptcy. And she said, these funds are exempt under the state homestead law as amended in 2010, which has a specific provision that says proceeds from the homestead are exempt for 1 year or until a new homestead's acquired. She hadn't acquired a new homestead yet. It was less than 1 year, so she said that this was exempt. This is a provision, obviously, is designed to allow the money to be rolled over into a new home, but they said the 1 year hadn't passed. So it sounded easy to me. The funds were exempt on the petition date. Creditors couldn't have reached the funds if there was no bankruptcy, and they sought the funds on the petition date. I thought that was the end of the story, and I was wrong. So 2 months after the bankruptcy, so now a year after the property was sold, the trustee filed an objection to the exemption. Judge Hillman had a hearing, took it under advisement. 2 months later, issues the 24-page opinion that you see in the book of Inri Williams, and he gives a lengthy discussion of the law on this issue, and I discovered that there's something called the Snapshot Rule. And the Snapshot Rule is a term for what I thought was going to be the law, which is that exemptions are fixed and frozen on the petition date. And what I learned is that the Snapshot Rule is subject to all sorts of limitations and parameters and cases that say one thing or cases that say the other, coming out all over the map with sometimes things are exempt and sometimes things are not. for whatever proposition you want to cite about the snapshot rule. You can give a string citation that's got a ton of cases in it. And in Williams, Judge Hillman found that the funds are not subject to the homestead exemption, that it was lost when 2 months passed post-petition, and it had been more than a year, and the funds were never invested into a new home. And so it's actually a little bit complicated in his opinion because there was still the probate court issue, so he actually continues the objection generally until the probate court enters its final order dividing the property. But I looked at what happened in the case afterwards. Looks like the probate court did that pretty quickly, and at that point, the trustee was entitled to turnover of the funds. And as I further read it, it looks like the debtor moved for reconsideration. That was denied, did not appeal, and then there was turnover motions, turnover orders, sanctions for not turning it over. Eventually, the trustee wound up bringing a 727D action for revocation of discharge, and at that point, we finally had a settlement where all the money plus the sanctions was turned over to the trustee, and the revocation of discharge was dropped. So, as I say, here we have something where time made a difference, and the money no longer was exempt. I want to just stop and interrupt myself and say we're a small group here, and this is it looks like it's a sophisticated group, and if there are questions or comments or things people want to ask, please feel free to raise your hand and do so, because I think that if we're small enough and we can be more interactive, that would probably be helpful. We're being webcast, so when there's a question, I am to repeat it so the webcast audience hears what I said. I will invariably forget to do this, so Dave, please make sure that happens if there are questions. Okay. To my knowledge, since 2014, there hasn't been any case in Massachusetts that relied on Williams or that dealt with this issue. At least there's no published one that I've seen. But recently, we've had the Fifth Circuit Court of Appeals weigh into this issue. And there's a case that's called Hawk, actually. There's two cases that are called Hawk, which are both in the book, and which I will talk about in a minute. Let me just give you the facts here. Now we have a debtor who, on the petition date, we're not talking about homestead anymore, debtor has an IRA. IRA has $133,000 in it on the petition date, and debtor claims that is exempt under Texas law. 7 months go by after the petition. The debtor winds up withdrawing all the funds, using it to pay living expenses. IRA funds do not get reinvested into a retirement account. Under Texas law, IRA funds are exempt, but if they come out, they're exempt for 60 days, and then if they aren't rolled back into another kind of retirement account, they're not exempt anymore. So as I said, 7 months goes by, the case happens to still be open because a creditor is bringing a discharge action of some kind or another. The trustee says, we now object to this exemption and say that the funds should be turned over. Because they're no longer exempt, you didn't roll them over in the 60 days that Texas law requires. The bankruptcy court has an evidentiary hearing. The bankruptcy court grants turnover to the trustee. The debtor appeals to the district court. The district court affirms. Debtor appeals to the the Fifth Circuit Court of Appeals. We have an opinion on July 19th of this year. 3-judge panel affirms. That's in the materials. The site for those who are interested is 864 F3rd 364. There is then a motion for panel rehearing. It's granted. The very same panel, I don't know if they have another oral argument or not, but they withdraw their July 19th opinion. They issue a new opinion on September 5th, 871 F3rd 287. It is the same panel, the same judge writing an opinion, but this time, all the lower courts are reversed. So, I guess I would say that this, I hope explains to you why I say that snapshot rule cases right now are all over the map. And with that introduction, I'm going to turn it over to David to talk about Hawk as well as some more stuff. Unless we stop now if there's anybody who wants to ask any questions? Okay?
Okay, thank you. Good afternoon. As Adam said, questions are welcome, especially since we're down one panelist, so it'll help fill in the space for the hour and a half that we have. In regards to the Hawk case, as Adam described, the facts are pretty straightforward. When I looked at it initially, I was surprised. But in reading it, and the reason why I'm bringing it into the segue into my portion of it, is the Hawk court applied the Snapshot Rule, and they said, okay, as it is, that's it. But one of the notations in the decision that caused me to pause on that is the judges, they gave a parting shot. They said that in citing 1306A, that had this been a Chapter 13 case, the results would have been much different. So then you looked at that and say, okay, that's the segue of the material that I have. So in a Snapshot Rule, clearly applies on a Chapter 7, 13, and not so much. So, and I know we have a number of people here that do 13 work, but 1306 basically enlarges what's considered as property of the estate above and beyond what's in Section 541. And it brings in all income, all assets that are post-petition that the debtor or debtors receives, including the post-petition earnings. So the question that I had in this section was, but what if the money received after the filing of the petition was from a properly exempted asset? My first example is a workers' compensation case. That was Inri Ortiz It's the site is 573 BR 703. It was a bankruptcy case out of North District of Texas just about 4 or 5 weeks ago. And a lot of the cases that I have are actually very recent. In the Ortiz case, that was a Chapter 13. It was filed in April of this year. At the time of the filing, the debtor had a workers' compensation case that was fully exempted. Objection deadline had gone past. No objections. At that point, you say, okay, I'm clear, I'm ready to go. What happened was that when they wanted to settle the case, I think it was about $8,300, $8,400. They had exempted under the D5, the wild card exception, 522 D5. The trustee, the Chapter 13 trustee at that point, filed an objection to the settlement, saying, no, the money should be mine. It's got to come to the Chapter 13 for the benefit of the creditors. Well, so the trustee filed objection saying that the failure for the debtor to meet 1325B1B of all projected disposable incomes, the case should either be dismissed or the money should be applied. Now, just for those that don't know, 13B2, that defines what disposable income is under the Chapter 13. So it's in addition to the 1306. It talks about really the post-petition income and monies coming into the estate or to the debtor. What's key on that is they also talk about, except for what's reasonably necessary, and there's two caveats to that. What's reasonably necessary, one for the maintenance and support of the debtor or the debtor's dependents, like a domestic support obligation and maintenance of the family, and the other one is charitable contributions. The court ruled in that particular case that notwithstanding that the exemption, the workers' comp amounts was fully exempted, that based on the 1325 B2, that the money should be coming into the estate. So the debtor and debtor's counsel files a case, they exempt the $8,700, money comes in after the petition date, and the money's gone, because the court found that it was not an asset specifically, but it was treated as income, and it had to go to the benefit of the creditors. This is out. It's not in Massachusetts, but it took me by surprise. I was very surprised on that decision, and I called one of the Chapter 13 trustees in Massachusetts, and they said, of course, under the Barbosa, it's all mine. So there you go. I'm sorry, Don?
So the court said that the workers' comp recovery was not subject to being exempt at all?
The question is whether or not the court, in its opinion, said that the recovery actually wasn't exempt or didn't comment on that at all.
No, what the court said was that, yes, it was properly exempted, but because 522 is not referenced in 1306, that the exemptions don't matter. So you could exempt an asset, but if it turns into cash, post-petition, that it becomes property of the estate, and it's treated as income. I mean, I have other examples of different kinds of categories of assets that are liquidated post-petition, and same results. It's,
So had the asset not been liquidated, the result might be different.
I would say that if...
Question is whether or not if the asset had not been liquidated, the result would be different.
So based on the court's reasoning, and the decision was pretty long, and it's in the materials as well. If, you know, sometimes workers' compensation can be treated as a steady stream of income instead of a lump sum. I know in my practice, I always tell my clients that's where you want to go. You don't want to do lump sum because, unknowingly, it was probably because of this reason. But if the case had not settled, resulting in a lump sum payout, and had just gone through a steady stream of income for a period of years, and the 13 plan was over, I would say that would be fine, based on the court's reasoning.
Well, of course, the steady stream of income would be income within the means.
Yes, yeah, exactly. Ann?
David, this is maybe more of an observation, but if it was pre-petition and a Chapter 13, Chapter 13 debtor gets an IRA distribution, that's something that the debtor has to handle when talking about their income, you know, their historical income. So it's not that surprising that you have to handle it both 13 as well.
Try to repeat that one?
Right. So the observation is that if the settlement was made in the 6 months before the month in which the petition was filed, then it would be part of the means test for calculation of disposable income. So maybe it's not so surprising that it's also dealt with in this kind of way.
Well, from my perspective, if I have a one-time lump sum settlement of $8,000 prior to the filing, say within the 6-month period, and Patty may disagree with me, I would take that as a once-in-a-lifetime payment. It would not be counted as part of the means test, because it's a one-time thing. Just like if you have a work bonus period, and you get a bonus every 6 months every year, and it's consistent over years, you've got to include that in your means test. But if you get a one-time thing and it's never going to happen again, there's an argument that says you don't have to, because it's a one-time income. If you settle the workers' comp for $8,700 and it's sitting there in a bank account and you exempt it under D5 and it's within 6 months, I think that's a discussion that the 13 trustee and debtors council will have, but I would take the position it's not income, or it's exempted because of the one-time payment.
You know, or I mean, it's not any different than income from a debtor who lost his job. I mean, it's a changed circumstance, so under that Supreme Court case that Patty always mentioned to me, whose name escapes me, you don't have to, you can look at what's on I and J and not look at the means test form, because this is a changed circumstance, it's not going to be repeated.
I think
Yeah, Patty?
it depends on how you're treating it, though. Are you treating it as income, or are you treating it as cash? Because if you need it for income to support the plan, then it has to be disposable income on the 22C form. But if you're treating it as cash, and it's in the bank, and you can properly exempt it under an allowed exemption, then that's fine. It just depends how you need to treat that.
Right, so to try to repeat, the idea is that if the money has already come in, it's going to be looked at as cash for the best interest test. And so if it kind of does make sense that you don't also then look at it as income.
Are you referring to a case that settled prior to the bankruptcy filing? Or are you talking about post-petition settlement?
What I'm saying is that if the debtor fills out a 22C form or a schedule, and in order to make the plan feasible, they're including this workers' compensation that they got.
Oh, God, that's what I'm saying, it was a payout prior to the filing.
Right, so
Yeah.
it depends on how you're treating it, on whether you're going to claim an exemption or not.
Oh, so if to balance the book, so to speak, if I need the $8,700 to make the minimum distribution based on liquidation, or whatever it is, then I would make that as a lump sum payment on day one when we file, and then the balance of it over. No, we agree with that. I'm just saying if I didn't need it, and I had $8,700 sitting in my savings account, debtors council, myself, I would say that's not considered income under the B-20.
Pre-petition,
Right, pre-petition.
post-petition is another story.
Exactly, that's what it says here.
I don't get why post-petition is another story. Well, because just like in this Ortiz case, if you
But on the Ortiz case, the judge says that the exemption amount is irrelevant because it's fully exempted. However, because it's 522 is not referenced in 1306, it has to be treated as income and then incorporated within the trustee plan payments.
Right, because the claim itself may be exempted at petition time, but just like any claim, if you settle a claim or you receive a judgment, it's property of the estate, you have to revisit the exemption to determine what you have available and whether it is exempt and whether it's income and how it's treated. I mean, there's a lot of stuff that happens post-petition that wouldn't happen pre-petition.
No, I agree.
Yeah, the point was made that if it's settled post-petition, it's still property of the estate and has to be looked at. I'm going to now ask a question of the audience, or a member of the audience, which what the heck, which is, are there circumstances in which money that comes in from a pre-petition asset would not be viewed as income? Or is it, I received money there during the case, therefore it must be income?
In a 13.
In a 13, yeah.
Well, for example, like life insurance proceeds.
That's one of my examples. Don't steal my thunder.
Okay.
I know you're correct. That's a separate exemption.
Okay.
But no, you're right, everything would be considered to be
Yeah.
income.
Right,
that's
okay.
coming in.
Right, so the point is, the starting assumption is that if you get new cash in from any source, asset, income, employer, whatever, it's income unless there's a reason it's not.
Yes.
Okay.
Okay, and that was the issue I was raising, but so that goes to the next question, and I don't want to go off topic too much, but this time of year is sort of like the feeding frenzy for Chapter 7 trustees on tax return money, right? So if someone who's not aware of exempting the tax return money, the 7 trustees are sitting there April and May ready to snatch it up. Well, let me just finish my scenario, Don. But on a 13, if I file a 13 today and my client has a $5,000 return expected, and we've changed the withholding so to zero out his returns in future years, isn't that $5,000 in the same vein as the Ortiz case? It's money that, even though I can exempt it under D5, it's money that's coming in after the petition date?
I mean, an income tax refund is a right to receive, it's either money received or a right to receive money, so why wouldn't it be income?
Right. Thankfully, in this district, we don't do that. Yet. Yes, Don?
So, post-petition, chapter 13, debtor sells house. So is that income now, and they have 100% plan, or not?
Well,
Can I repeat that?
You
So the question,
Right.
yeah, so the question is, same scenario with Chapter 13, debtor files for bankruptcy, but then he sells his house post-petition that's fully exempt. The proceeds of the house, is that then protected under the exemption? If you apply the Ortiz logic, I would say that probably would be exposed, but I haven't seen it. I have sold houses, not me, I have had my clients sell houses in a 13, and it has not played out because it's been fully exempt. But you're right, the logic would be the same.
Or do you have to wait a year and see if the money gets reinvested into a new property?
As we said, there's a lot of issues that go up, and the case of the Ortiz is from Texas. It's from Texas. So it seems like a lot of the cases that I'm going to talk about with the 13 exceptions to exemptions, they're all in the western part of the country, and hopefully they're not going to migrate here. But we do have a couple of 13 people that may want to do that. But so that is going back to the Ortiz and the workers' comp. What I said was, one of the comments that the court made was that the debtor's counsel did not make any argument towards the reasonable and necessary component of 13b2. So, as a practice tip, which myself as well, if I was faced with this scenario, part of your pleadings, you would have to make an argument, at least to get past the threshold of denied, you at least have to get a hearing, is that you'd have to make an argument that the monies that's being received from whatever it is, workers' comp, the IRA, whatever, is a reasonable necessary in order to support your family, your dependents, your charitable organization, or whatever it is. Some of the exceptions to the 13b2. I'm sorry, 1325b2. If you don't make those arguments, you're dead in the water. It appears there's many cases that find that's the case. But the ones that I have, and a couple more to follow, the judges specifically said they did not make an argument under the reasonable necessary standard. So in all the cases that I have, if they had made that argument, would the results be different? I don't know, but the court seemed to indicate, at least in a kind of a cursory reference, that it would have been different. So in the Ortiz case, the last thing I wanted to bring, it has nothing to do with the exemptions. I just wanted to throw it out there with the mindset of the court, is that at the end, the court stated that, and I want to read it, exemptions are less significant for Chapter 13 debtors, which that's news to me, I didn't know that, and that given the broad discharge afforded debtors under 13, having the debtors pay otherwise exempt income to their creditors furthers the goal of making 13 debtors pay as much as they can to their creditors. That was eye-opening. The exemptions are less important to a 13, but I just wanted to throw that out there. The next case I wanted to talk about is regarding life insurance, one Patty kind of referenced. This one just north of the border was a New Hampshire case, Larry Sumsky, the 13 trustee. It's Inri Missoula. It's 525 BR 569. And this came out a couple years ago. The facts of this case is the debtors filed bankruptcy, husband and wife, 2012. 2 years later, one of their parents passed, and they, I forget which one it was, let's say it was the wife, was in position to receive some amount of money. The 13 trustee heard about it and filed a motion to amend the plan. And he didn't know how much the debtor was going to get, but his motion to amend stated that, and it was based on the 1329A, he said he wanted the lesser of either $176,089.47, which would have made for 100% dividend, or the full amount of the non-exempt portion of the inheritance. The non-exempt portion, I don't know what the court meant by that, because can you exempt an asset received 2 years after the filing in the 13? But ultimately, in that particular case, the court ruled in favor of that Chapter 13 trustee. He argued that a plain reading of 1306A1 requires every kind of property acquired post-petition, but before being closed, dismissed, or converted, to be incorporated into the plan's payments. And that's a Barbosa statement. I mean, that's basically what we've been talking about right along. The court ruled that the insurance proceeds were property of the estate and must be used to fund the plan. And they also got into that 1306 does broaden 541, which is the definition of what the bankruptcy estate is, and I talked about that in the Ortiz case. So that's in New Hampshire, and I know Massachusetts follows that rule too. I don't have any cases from Massachusetts, but it's pretty basic. If you have a debtor who is standing to receive an inheritance prior to the case being closed, the money's got to go to the trustee up to 100% of the dividend or the whole inheritance, whichever is less. So I'm sorry. So there is a case, and I apologize. Judge Feeney actually referenced the Missoula case. It's Inri Lombardi. It's 551 BR 84. And again, it's Mass 2016. This one is a little bit. I was hoping Walter was going to be here because he was on the downside of this case. He would have been able to explain it. It's a complicated case, but he took over for the debtors' counsel took over for somebody else, and it was a 36-month plan. And there was a lot of logistics. And I know Carolyn and Patty were involved in this case, but there was a lot of logistics involved in timing. Ultimately, what happened was the inheritance came in. Or the debtor was about to receive inheritance. Trustee finds out, they object. They file a modification to amend the plan. The timing of that is that the motion to modify was after the final payment date per the confirmed plan. But the problem was the debtor still had a couple more payments to do. So the debtors' counsel argued that no, the plan was done. It was ready to be delivered. The court found that because, and again, this is timing is everything. This is just a few months out, and I believe it was a few months. That because the payments had not yet been concluded, even though the planned payment was scheduled to be concluded, the payments had not been. Because the payments were still out there, there's a few more. That the money coming in was property of the estate, and was turned over. I believe was it turned over, Carolyn? It was okay.
So as we tell our debtors over and over again, there's no end to the problems that can develop if you fall behind with your Chapter 13 payments, right?
Yeah.
Because if they hadn't fallen behind, they wouldn't have had that problem.
Right, so what I've done is, I have 4 cases that have come out since I submitted my materials just last month. And I'll just go through them. They're not in your materials, so I'll give you the sites. Some of them are on, one of them is actually an unpublished, but I just want to go, it just seems like there's a flavor or a trend. Again, it's kind of away from the West Coast. But anyway, so this first case is Inri Earl, E-A-R-L. It's 2017 U.S. Appeals. It's Lexus. I have Lexus, not Westlaw. It's 23914. Just came out November 27th, last week. Unpublished Ninth Circuit. And this one went against the debtor. The debtors filed a Chapter 13, which was later converted to a Chapter 7. When this debtor first filed the 13, she had 2 properties, one that she lived in, one that she rented out. Her intent on the 13 was to try to save her house. During the process of the 13, it didn't work out. She lost it through motions for relief or whatever. She just couldn't save it. So at the time of the converting, she files a conversion, and then she changes her exemption. She files an amended Schedule C and exempts the second house as her primary residence. And the trustee and the 7 objected to that. Okay, so this is a timing is everything as well. Ultimately, what happened was the court upheld the trustee's objection, and both the district court and the Ninth Circuit upheld the decision as well. It says, although both federal rules and bankruptcy of Arizona allow a debtor to assert a post-petition exemption, a debtor may do so only where the exemption could have properly been claimed as of the petition date. So again, timing is everything. So that's Inri Earl.
So this is sort of the snapshot rule backwards.
Yes.
Because you have,
strategy there would have been to dismiss the 13 and file 7.
Oh, yeah. I mean,
I mean, it was,
so the question,
Yes.
so the question was, the strategy from a debtor's perspective probably should have dismissed first and then refiled.
would have removed the
Yeah, then you have the change in circumstance argument, but then, that's an easy one to make for.
one of the-
Sure, go for it.
somewhat routinely, when people go to a 13, I ask them about their parents' wills and suggest that they be changed to put any inheritance into a spendthrift trust. Does anyone see any problem with that?
first of all, the question is, if a Chapter 13 debtor's parents change their will to put any inheritance into a spendthrift trust. And I guess I am aware of cases which distinguish between the testamentary trust that's not funded until after death and the inter vivos trust that is. And if it's a testamentary trust, I think it's going to certainly fall into, 541A5, the one that says if you inherit within 180 days of filing, it's property of the estate. If it's an inter vivos trust, it's not so clear that it does.
In the first case, that would defeat the spendthrift language that would otherwise be represented.
Yeah, well, okay, so it's not just going into a spendthrift trust. The trust, the debtors will not have any rights to take the money at any time after their parents die. Is that the way it would work?
About what advice you
Yeah.
give to the debtor to tell their parents' lawyers you have to make these changes in their will. If you have this problem.
Well, I can. So I had a couple cases in recent years. One of them, it was an individual. Parents had a trust, naming the child as a trustee and the beneficiary. I didn't like the language. I didn't think the spendthrift was strong enough, and I told them that, I don't recommend you filing because I think this trust is exposed. The attorney who drafted the trust disagreed with me, and I says, put it in writing, tell him that indemnify, and he did. The 7 trustee, it was a Worcester case, went after the trust and got it. So, okay. The other, what I've done in the past, I have one I'm working now, if your parents leave money to you, just have them change you, just take you out of the will. You can't tell your client to secret away assets, but you can certainly have his parents remove them from the will. I don't think that's a violation. If anybody else has has a concern with that. Don, do you have a concern with that?
There's a case on that that says you can disinherit a trust. It's a mass case.
Yeah,
McGuire that says you can disinherit.
yeah. But
As
it-
long as you've done it, obviously, before.
be pre-petition, yeah.
It's the parent's property.
Exactly, and that's what I do, and, you know, and if they want to rename them 8 months after the 7's, you know, closed and done, that's up to them, but it's,
I routinely give that advice and usually get ignored. I just say, they tell me they're not gonna die.
yeah. Well, if, like I said, the one I had with a trust attorney wrote me a letter saying they didn't believe there was any issue with exposure. They probably didn't wish they wrote that, but they did, and it saved me.
But now you have a good thing to tell your next clients about.
Yeah, I use that example, that happened 2 years ago, I use that all the time as an example, because it happens.
On the question of strategy, we mentioned the strategy on the issue of which homestead applies of dismissing and then just refiling a new case. On the case where you get the inheritance or life insurance more than 180 days after filing, can you just convert to Chapter 7? Because one of the things that I have learned is that just because something is property of the estate in Chapter 13 doesn't mean it's still property of the estate after the conversion to Chapter 7.
I mean, my opinion, and maybe Carolyn or Patty can jump in on this one. If I had a case, well, I had a couple that paid out, debtors received inheritance, and it was Denise's, and they both paid to her. But if I had converted it, they're sitting there with like $130,000 in their checkbook.
It has to be a good faith conversion.
Right,
It
right,
has to be
yeah.
property of the Chapter 7. I would argue it's not good faith.
Right.
The point is that, and that's the issue, would the motion to convert be challengeable on the basis that it's not good faith within the meaning of Marama?
And quite frankly, if you file a 13 and you have a lot of unsecured creditors and the interest and penalties have all stopped, I'm in my position, I've told my clients, it's just pay. It's a lot cheaper than if you dismiss and try to settle, it's going to cost you more because the interests have been frozen. In one case, it was almost 4 years into it. So the other case I wanted to talk about quickly is it's Inri Awada. This one just came out October 18th, 2017. Site is 574 BR 692. It is Central Division of Illinois. This is actually in direct contradiction to the Williams case. So in this case, almost exact same pattern. They have in Massachusetts we have, Mass General laws, we have 188 Section 11 that says that, you have, if you sell your primary residence, you have to reinvest it within a year. And that's what the Williams case stands for. Illinois has the exact same statute, same period of time, the whole 9 yards. Facts are the same. File bankruptcy. Person passes. The person passes away. They file bankruptcy. They're sitting there with a bunch of money in their account, and the 7 trustee challenged it based on because of the money they had it. They had it invested. It's sitting in the bank. The court ruled that even though they had not invested it within the 1 year period, that because, one of the other thing in Illinois is they actually had to do something with it within 60 days, actually, it was 60 days. And because when the date that they filed, and this is a clear demonstration of what the snapshot is, because within the 60-day period they had filed for bankruptcy, the court said that they have an absolute right to rely on the exemption amount. It says the debtor is entitled to unconditionally claim her exemption proceeds as exempt because she did it within that short window of time. It totally contradicts what Williams stands for with the Judge Hillman case. So again, that's site 574 BR 692, 2017 case. It's Central District of Illinois. Another case. We're running out of time.
Got 5 more minutes to use.
Okay. The other case I wanted briefly, this came out October 20th, 2017. This is Inri Cuevo. Debtor was laid off prior to filing Chapter 7. Proceeds from her 401k were wire transferred into her bank account the night, talk about timing, the night before her bankruptcy was filed, and didn't tell her debtor's counsel. So I'm sure the trustees would love to see that case. At the 341, the 7 trustees asking these questions, and they find out that they got this money, and they instruct the debtor not to spend it. But unfortunately, the debtor had already spent the money. They just went through it like water. And so it says, although the court found the trustee's objection to the claimed exemption as moot, as the money had been spent and no longer was in possession of the debtor, it went on to discuss the snapshot rule. It says, in the instance where a terminated 401K, the court stated that the debtor had a short period of time in which to apply the proceeds to another qualified account. And on the petition date, the debtor was within that period of time. And again, so it's the same thing as the Iwato case. Although not issuing a ruling on this portion, the court, in citing the Hawk decision, stated, simply notes that the rule may have favored the debtor on the merits of the objection, but the inability of the trustee to recover the proceeds, even if he prevailed on this issue, renders the matter an academic point. So the court actually issued a kind of like an advisory saying, it doesn't really apply, but this is what I would have done if. The irony in that one is it says that the money was already spent. I know in our jurisdiction it doesn't matter, but that court cited Brown versus Pratt, 486 Fed 3rd 423. It's an Eighth Circuit case. Said that if the money is spent, you can't force the debtor to turn over money that's already been gone through. And I know that's not the position here, but hopefully when all the other things come east, that will come too.
I'll just say that can't be right. Maybe it's because I spend most of my time representing a trustee or two.
Yeah,
but,
that was another one of my eye openers. And the last one I have is Inri Bird. It's a Utah case. Just came out November 30th, so it just came out, I think, Thursday. Ruled against the Chapter 7 trustee's application. So this goes to, I know anybody who does 7 work, if your client has a house that they're letting go, the 7 trustees sometimes are trying to do short sales, and they're trying to carve out certain portions of it. This court basically eviscerated the Chapter 7 trustee. So in this particular case, the debtor filed for bankruptcy. The 7 was working out a carve-out, including a negotiation on I think it was $60,000 on an IRS where they agreed to take much less. And the proposed settlement would have been $40,000. $30,000 of it would have gone to the 7 trustee and the expenses, and a little less than $10,000 actually was going to go to the unsecured creditors. So the debtor filed a motion to convert to a 13, which was granted, and then the 7 trustee filed a fee application. He exposed himself to the court's wrath on this one, and the majority of this case was written against the trustee, and how can you do that? And the statement that the court stated was that the trustee sought to manufacture equity through the stipulations and carve-outs with the IRS in order to sell the homesteads and generate funds that would primarily benefit the trustee, counsel, and bankruptcy professionals, while only minimally benefiting unsecured creditors. Almost all of the services for which the applicant seeks compensation are in furtherance of that inappropriate plan. So I know if anybody has a 7 case where a 7 trustee is trying to carve out and sell their house on a short sale, you don't have to agree to it.
well, I mean, this is a bad facts make bad law kind of situation, because as somebody who represents trustees who do short sales, the critical thing in any short sale that my trustee clients do is that the debtor goes along with it and wants it to happen, because from the debtor's point of view, having an orderly process where they're in control of, when the house is sold, whether, maybe there could be relocation as part of the deal with the short sale lender, but you have an orderly process as opposed to a foreclosure followed by an eviction. Yeah. And that can be worth it to a debtor in return for saying, okay, I'll waive the homestead exemption that I'd never get anyway if you didn't try to do this short sale.
And I agree with that. As a debtor's counsel, I always, if my client are surrendering a property, I welcome a 7 trustee trying to do that, as long as my client is willing to put in the extra time and meet with the short sale person and sign the documents and so on, because ultimately what they end up doing is through the short sale, the trustee does get that carve out, but they do pay the debtors anywhere between $2,000 to $5,000, depending on the lender and how much money they can carve out, so it gives them moving expenses. So as long as all parties agree and you have a meeting of the minds, it's good.
And even if you don't get relocation, you at least typically get time, because no short sale gets negotiated in less than 6-8 months at this point.
And,
with what the lenders want.
We could have a point counterpoint here, because as debtor's counsel, if my clients, although they're surrendering their property, if their angle is just to stay in the house as long as possible, that's not through a short sale, because you can stay there as long as possible, much longer than a short sale. But with that, I will pass it off to Adam.
Okay. So I'm now going to talk, change gears now, and stop talking about timing as much, and talk about our favorites from BAP CPA, 522 OP and Q. And I'm going to, I'll start by saying, you know, we have two general thrusts for these provisions. One is limitations on attempts by debtor to convert non-exempt assets into a homestead before filing. And the other is limitations on attempts to use the homestead as a shield from liability for what Congress considered to be bad conduct. And the second one is 522Q, which I'll start with. And 522Q says if you have a debtor who's engaged in securities fraud or engaged in intentional tortious conduct resulting in serious bodily injury or death, then the homestead exemption gets capped at what's now $160,375. It's a number that changes every 3 years based on inflation. And that cap is, in 522Q, there's an exception to the extent the homestead interest is reasonably necessary for the support of the debtor and any dependents. And I mention it, but the fact is that there's virtually no case law on this. It comes up very, very rarely. You know, maybe we've got Congress surprised that people with these kind of debts don't seem to have big homesteads. But as I say, I think in the whole 12 years, there's probably been, you know, less than a dozen cases on this provision with any degree of analysis. 522O is used a lot more. That caps the homestead exemption to the extent of value attributable to property disposed of with the purpose of hindering, delaying, defrauding a creditor in the 10 years preceding the bankruptcy case. So you take non-exempt cash, you use it to buy a new homestead. If your purpose is hinder, delay, defraud creditors, the amount of cash that is converted into the homestead is not exempt. The big issue here, of course, is what is action that is done with the purpose of hinder, delaying, or defrauding a creditor. And there, the case law has pretty much coalesced and said that we've had this standard in the bankruptcy code for already. It's the same standard as 727A2A, where with that kind of intent, a debtor disposes of property in the year before bankruptcy. If they do it in the year before bankruptcy with that kind of intent, the discharge is denied. And we have a large body of case law on that, and the 522O cases seem to be relying on that and setting essentially the same standard. So, you know, when you have the bad intent, if it's done within a year of bankruptcy, you lose the discharge. And if it's done within 10 years of bankruptcy and goes into the homestead, you can lose a piece of the homestead. And as I say, there hasn't been much new cutting-edge stuff on that provision recently. And then we have 522P. And 522P, 12 years after the enactment of BAP CPA, is still a subject of hot dispute over just what it means to begin with and what the basic theory is. So 522P caps the homestead exemption that can be taken in the amount of an interest in property acquired within 1,215 days prior to the petition date, except to the extent that such interest includes something transferred from a prior principal residence in the same state. So we have a whole bunch of different rules that apply here to make it come in. This again, you do this. It doesn't mean you lose the homestead. It means you have a cap. It's the same cap as 522Q, currently $160,375, and also indexed every 3 years. But if you have this acquisition within 1,215 days of the petition, which is 3 1/3 years before the bankruptcy, the exemption's capped irrespective of intent unless you have this safe harbor transfer, and it's got to be a transfer from a property in the same state, which, you know, where you live in the Northeast and the states are small, you know, that can be result in some very bad things for people who really aren't intending to play games with their exemptions. The idea of 522P, everybody agrees, it's, quote, plug the mansion loophole, end quote, which is a phrase you see over and over again. And it is, we want to stop debtors from buying mansions in Florida or Texas with unlimited homesteads, and of course, to some extent, Massachusetts, which may have one of the biggest monetary homesteads that isn't unlimited. This was done, you may remember the old baseball commissioner Bowie Kuhn. He bought a giant house in Florida and then filed bankruptcy. Enron executives did it in Texas. But 522P has language that covers a lot more than just mansions. And so that's where we have the statutory interpretation debate about some of these words. You know, what is an amount of interest acquired? When's there a transfer from the previous residence? It's all subject to interpretations that can go either way. So that's our backdrop, and let me now mention a case that came down in March of this year, Inri Williams, 566 BR 102. In the book, it is a Judge Bailey decision. So let me, the facts are complicated. Let me outline the facts and then talk about the simple parts and the more complicated parts. So we have a debtor and his wife who for 14 years owned and resided at a property in Arlington. They decided to sell the Arlington property and buy a new property in Winchester to live at. But they buy the Winchester property first. They buy that in October of 2014. Purchase price is $1.185 million. They put $385,000 down, which comes from some sort of non-exempt assets, doesn't come from any rollover of exemption. And there's an $800,000 mortgage that the debtor gets from his father. Just because we want to make things complicated, the debtor and his wife immediately transfer the property from tenancy by the entirety, which is how it's purchased, into a nominee trust whose beneficiaries are debtor and wife as tenancy by the entirety. So it's exactly the same economic effect. It just goes from T by E to nominee trust with T by E as beneficiary. Okay. So right now, at this point, if the debtor had bought this property, moved into it, and then filed bankruptcy, you'd have the 522P question would be simple. There would be $385,000 of equity, and that would be capped by 522P, and it'd be only the $160,000 homestead exemption. And I might as well say now, this case also presented the very complicated fact that only one of the two spouses filed bankruptcy. And the question of how the 522P cap on a single debtor and the Massachusetts homestead exemption, which creates an exemption against property, even if it's owned by two people as joint tenants by the entirety, how that interplays, I can't tell you. It is, I haven't seen cases on it, and analyzing it was very complicated because the two things just aren't designed to fit, where you have a cap on one debtor, but an exemption which applies to the property, even if owned by two debtors. All right. So back to the facts of Megradician. So they buy this property in Winchester in October of 2014. They then sell their property in Arlington in December of 2014, net $517,000, take $500 of that, pay down the mortgage on the Winchester property. So it now goes from an $885,000 loan to a $385,000 loan, and I'm sorry, from an $800,000 loan to a $300,000 loan, and the equity goes from $385,000 to $885,000. And then, just to make it even more complicated, in August of 2015, so we're now about 8 or 10 months after these transactions, property gets deeded back from the trust into the debtor and wife as tenancy by the entirety, and then they file Chapter 13. So that's the situation that was seen when a deadline to object to exemptions came up, and there was an objection filed on the basis of 522P. And I should, again, whatever it is, there's clearly going to be some equity in this house that's not exempt, because at the time of the petition, you've got $885,000 of equity and at most a $500,000 exemption against that. But is it a $500,000 exemption or a $160,000 exemption? So let's start with the very last transaction. On the eve of bankruptcy, property goes from trust to debtors individually. Clearly less than 1,215 days. So is that an acquisition of interest by the debtor? Because if it is, 522P applies. And we have two schools of thought on this, essentially one is called the title concept and the other is called the equity concept. And the title concept says, look, you had a deed, it changed title, trustee of a nominee trust gave it to debtor and wife, deeds recorded, transferred interest, titles changed. As soon as that is received, the debtors acquired an interest, and we have an acquisition of title interest, therefore we have a cap, because that event going from trust to tenancy by the entirety triggers 522P. And we have the equity line of cases. And those lines of cases don't look at title, but as you would expect, look at the equity in the property and did the debtor's equity change. And so before the transfer, the debtor had, through a nominee trust, equity in the property as a tenant by the entirety. That's how the beneficial interest was held. After the transfer, he now has the exact same amount of equity. He just has it without the intermediation of a trust. He has it directly. His equity hasn't changed, so those cases say there was no acquisition of an interest, no cap. And we've had an awful lot of cases in the last 12 years on 522P that go both ways. The cases will typically say whether they say title or equity, they say, our position is the majority position. Collier's says that title is the right answer. It says acquisition of interest means ownership or fee interest, and so title is what you acquire as one's own. Equity isn't something that you acquire in the same way. And Collier's and the title cases also point out that if it's equity that matters, then homeowners can get penalized for mortgage payments, home improvements, market appreciation. All those things increase equity. And that doesn't seem to be at all the kind of thing that 522P was intended to do. And then the other point the title cases make is that when it comes to things that simply change the amount of equity in the homestead, we already have 522O, which says that if you do that with bad intent, then you lose the exemption in whatever it is that you put in to the homestead from non-exempt assets. And the logical interpretation is, well, if you lose it when there's bad intent, then maybe when you don't have bad intent, you shouldn't lose it just because you transferred from non-exempt to exempt and changed the equity. So 522P should be different than an equity theory. So that's what the Colliers and the title cases say. The equity cases, well, they say you're only looking at part of the statutory language, because the statutory language doesn't just say acquisition of interest. It says acquisition of amount of interest. And when you throw in the word amount, you suddenly have a quantitative monetary interpretation. And that suggests that we have equity. Plus, remember the safe harbor that was mentioned, which says that if part of the amount of interest that's acquired comes from a previous residence in the same state, then that is protected from the things the cap applies to. And that safe harbor is clearly based on numerical amounts and equity concept, not a title concept. Some of the equity courts then say, and this worry about passive things like market appreciation, well, remember the statute says acquisition of interest. And when there's market appreciation, there's no affirmative act where there's no acquiring. And so if just passive market appreciation, that won't trigger 522P. So that's the battle we have, the title cases and the equity cases. In Megradician, Judge Bailey joins the courts that say equity is the right reading of 522P. And he does it based on a very close and careful parsing of the words of the statute. Amount of interest suggests something quantifiable. The focus is on quantifiable economic value. Equity is what you routinely speak of as quantifiable economic value. It would be really strange, he says, if somebody says an amount of title, but amount of equity is an easy thing. And then in particular, he finds critical the 522P2B defense involving rollover of amount of interest. You can transfer equity from one residence to another. You really can't transfer title from one residence to another. Title is always property specific. So that's the reason that Judge Bailey gives in adopting the equity interpretation. And once he does that, the result in Megredician becomes fairly straightforward. That transfer that I mentioned at the end, where you go from nominee trust to title held in the beneficiary of the nominee trust, doesn't change equity in the slightest, therefore doesn't trigger 522P. Right. Now let's go back to the earlier facts, where you have acquisition of property in October and rollover not until December. As I said, if at the point of view of October, when he just acquired the Winchester property, doesn't matter if it's title or equity. If it's title, well, title changed less than 1,215 days, there's a cap. But if there's equity, well, he acquired a house which has $385,000 of equity. And that is an equity acquisition, that's subject to the cap. Now, how did things change because of this $500,000 that's rolled over from the old house 2 months later? If you had a title interpretation, that wouldn't be relevant because title didn't change. But under the Judge Bailey's equity interpretation of Megredician, the $500,000 payment in December of 2014 against the mortgage, well, that itself is an acquisition of equity. Just went from $385,000 of equity to $885,000 of equity. So that event would be subject to the cap, except the $500,000 came from a previous residence in the same state. So because of that exception, this $500,000 acquisition of equity is not subject to the cap. And then, of course, once you have $500,000 of homestead that's not capped, the rest is irrelevant, because $500,000 is the maximum homestead you can get, period. So as a result, the objection to exemption was overruled.
Adam,
Yes.
could you have, was there an objection to 522O to the money that came over from the sale of the prior residence?
No, there was no objection filed. Oh, let me back up. I'm fairly sure there was no objection under 522O. I mean, it's hard to say that money that came from your old house and went into the new house, went to pay down the loan on the new house was with bad intent. I mean, they clearly had the idea of buying and selling at the same time, simultaneously. So, it's hard to argue that that was some sort of a intent to hinder, delay, defraud creditors. It was an intent to move up in terms of the house. And of course, the Arlington property, it had $517,000 of proceeds when it was sold, so it had no equity above the homestead to begin with. So, had he just kept Arlington and filed, he'd have had $500,000 of homestead. So the fact that he now gets $500,000 of homestead for Winchester doesn't seem to change anything. In order to reach his result, Judge Bailey does a very thorough canvassing of a lot of other cases. You want to see the cases out there on 522P. He talks about pretty much all of them. They're all outside the First Circuit with one glaring exception. There's a case called Ortiz v. Vankowski, 385 BR1. That's a First Circuit BAP case from 2008. And that's a case where you had a debtor who had lived in their house for a heck of a lot longer than 1,215 days, but the house was owned in a trust. The debtor was the sole beneficiary. During the 1,215 days, property gets transferred from trust to debtor individually. And arrestee holds that the cap applies. It's an opposite result from Megredician. And the way Judge Bailey addresses arrestee in his opinion is that he says, well, they interpret 522P as the language that arrestee uses. It means some legal or equitable interest that can be quantified by a monetary figure or simply as equity in the homestead. So even though arrestee reaches a result that's consistent with the title theory, it does it by using language that's more consistent with the equity theory. And so the basic comment that Judge Bailey makes is it's not a helpful case to him. But it still comes out the complete opposite of the way that Megredician does. There's been one other 522P case in the First Circuit that I'm aware of since Megredician. That's a case called Inri Williams. The site is 570 BR 680. That's a case of Judge Hoffman's. And Judge Hoffman describes Megredician as a persuasive and thoughtful opinion. So it certainly sounds like he is in the equity camp in his interpretation. But the facts there, the debtor would lose either way, because in Zakarian you have a debtor that was the trustee of the trust that owned his house, but he wasn't the beneficiary, and it was transferred to him during the 1,215 days. So either way, title changes and no cap, or equity changes and there's no cap. And that's what I got on 522 OP and Q. So I'm going to open up to questions for that or anything else, or if not, I guess we can leave early. Okay?
Guess we'll leave it early.
I guess we'll leave early. All right.
Only 6 minutes, though. We made up for 1/3 of it. That's good.
Okay. Thank you, everybody.
Thank you.